I will never be able to say that out loud.
It feels like the Flintstones live there.
It does.
Well, don't trust women. I think you just touched on that with your last. That's what they brought. We're going to have to bring back chaperones.
Jesus, no.
Just careful. Stop! Break! Ooh. Hard right.
How did you screw up a stove, Megan? You're a woman. I thought that was baked into you, like at the genetic level, how to operate kitchen equipment.
And honestly, Megan, if you don't like it, I'm sorry. I've been very nice to you.
You get Dino hanging out outside chewing on a large bone. I highly recommend being targeted by the New York Times and Rolling Stone for weight loss. And I'd say, keep it coming. I need to lose 20 more. Please, keep it coming.
Explain to me, Megan, why did this country not have a holiday once a year? That's the time you vote. If you don't show up and vote, up your ass. You don't get another chance. You don't get, I don't care if you're in the hospital. Crawl to the stake, crawl there. But that's it, 1 day, 12 hours, and then you're done. And you count them that day, and that night you know who the hell won.
I will eat you alive. You want to tangle? You want to go?
The only thing going through my head is, what are you going to do when Megan Fox runs wild on you, brother?
He made a deal with the devil. She's the devil.
He wants that.
Oh, God. Gross! Oh! All right. Penalty box for Slug. Yep.
Of a mile.
Are you ready to behave yourself now, Slug?
This frustrating rep.
Are you ready to behave yourself? Repossessed puppies. I'm hiding Pork Chop. ASAP. Have you seen his little pork chop? Oh my God, Pork Chop is the cutest.
That sounds bad.
Have you seen it?
Pork. It's pork.
Though you may be tempted, do not contact any person or persons mentioned on this stream. Do not even think about contacting anyone who may be the topic of the daily news. If you should do that, the host will question your IQ, possibly call you names, and mock you for disobeying these basic rules of decency.
All the best.
What's up, everybody? Welcome back to the program. Sorry I'm late. I had an appointment early this morning and I had to go and take care of that. So I was going to do Karen Reed Emotions Hearing live, but I couldn't. So we're doing it a little bit afterwards. So, but that's good because then I can fast forward through the boring parts. So hold on a second. Where is it? Let's pull this up. No spoilers. I have not watched it. I have not seen any news. I did just get my hair done. Thank you. Yes, I got my hair done. So I got the professional blowout. You know, it's always good when I get the the professional hair. You know, they do the whole thing. Let's see. Here we go. So those of you who have not followed this case, it's one of the craziest and most corrupt things I've ever seen in my whole life. I mean, the Karen Reed. So Karen Reed was accused of hitting her boyfriend, John O'Keefe, who was a Boston police officer, accused of hitting him with her car, somehow backing up into him and sending him flying 30 feet in the air into the front yard of the Alberts house. And somehow she didn't notice this. She didn't notice that the only damage to her car was like a little cracked taillight. And, but strangely enough, when they found him, he had what looked like dog bites all over his arm. And, we still don't know where the German Shepherd Chloe is. Justice for Chloe, man. Justice for Chloe, because, we don't know where Chloe went, but they had a German Shepherd. Mysteriously, it didn't bark. When all this craziness was going on, when there were cops like 5 feet off the window from where Chloe was sleeping, allegedly, no barking, no dog. The dog just disappeared, just never came back. Um, there was blood evidence that was gathered in Solo cups. There was taillight evidence that was found days after the incident. There was a leaf blower used. There were fast food bags involved. I mean, it was bad. It was bad, you guys, real bad. So this is of course, it ended. The original trial ended in a hung jury, where the juror, I don't know if you saw this. Oh my gosh, hold on. So Turtle Boy just had a interview with one of the jurors. Did you see this interview? And it was awful. The interview basically, we should maybe go over that at some point, but it basically gives an insight into why juries are uneducated about what reasonable doubt is. Because this jury, they didn't give any weight to any of the defense's experts. They just basically thought, well, they're hired by the defense. But they gave all the weight to the prosecutor's experts. What? It's the same thing. It was, yeah. Were you screaming throughout? I was screaming too. It was bad. I mean, and anyway, that juror confirmed that they all voted to acquit her on 2 of the charges, the leaving the scene, the murder charge, and the only thing that was left was manslaughter. And so she should have been acquitted on both. But of course, the judge did not pool the jury. And so she's getting tried again on the same things. It's double jeopardy. It's terrible. So this is the second trial. We are in the pre-trial hearings. I saw one last week that was them arguing a lot of the same motions that I think they're going to talk about here as well. They're going to talk about, at least from the article I read, this is going to be about the prosecution wanting the media's notes from her interview, which is, I would never give those up as a journalist. I would never give that up. No way, man. They're not entitled to it. That's journalistic privilege. And I don't think that a court should be able to order them to give either the edited stuff or the notes, the handwritten notes. So it's about that. It's going to be about the defense wanting the prosecution's dog expert kicked off. They don't want that testimony in the new trial. And also the missing tape. Where is the video of Karen's car when it's brought into the police station, the Canton police station, and there's all kinds of stuff missing from it, and these pieces of it keep coming out in drips and drabs? Like, where is the full video? So that's what this is going to be about today. It should be pretty interesting. Let's get into it. No spoilers if you've already seen this, because I haven't. Let's see.
Good morning, Your Honor. Laura McLaughlin for the
Oh,
Good morning, Ms. McLaughlin.
One earbud.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan.
Good morning, Mr. Brennan.
Oh, God. I have to boost the
Good
volume.
morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right. I was told counsel wanted to see me at sidebar.
Briefly, Judge.
Okay.
Oh, we're sidebarring already? That's what's great about not watching this live, though, is that I can just fast forward through all of the sidebars. How are we sidebarring already? Alessi's pretty chipper today. Is he new? I don't feel like I've seen him before.
I'll have the paper numbers on these. You probably do if you've been looking at mass court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Now, Brennan is the new prosecutor. So Lolly is not on this case anymore. I think he's become a witness, hasn't he? In some way. But anyway, Lolly's not on the case anymore. And Brennan is, and he seems better than Lolly, in my opinion. I mean, he doesn't, I just think he's better than Lolly so far.
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety.
Ah,
They've asked for the courtesy if I could wait until March 1st to receive all of the information.
so they're just giving it up. Unbelievable. Is that what he's saying? That the media is just going to give him all of this stuff that they've left on the cutting room floor and the handwritten notes? They're just agreeing to it. This is terrible. Media should not do this. And, you know, when she did that interview, I thought to myself, this is stupid. You're going to be tried again. You should not be being interviewed at all. And look at how they stab her in the back and they're just going to give whatever. They're just going to hand it over. Unbelievable. This is very bad. I wouldn't have done that as a journalist. I would have let them put me in jail first. Nope. If I tell a source, and according to the testimony and the motions, the interviewer told Karen that certain things were off the record. And if the things are off the record, that means it's confidential and it doesn't leave the journalist between the journalist and the source. And now they're just going to hand it over? Oh, yeah, I saw the juror interview. We may have to go over that later.
I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you said?
They'll have it on or before March 1st.
Okay.
Terrible.
All right, so that motion is allowed by agreement and the order is right here, Mr. Clerk.
What a joke.
All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right?
All right, I can't help myself. I have to give a hair review here. Bev, oh, good Lord. This, you know you're going to be on national television, right? This is the problem with the bleaching of the bleaching of the hair. It becomes like straw. You see how it sticks out in these weird little, here, let's see if I can show you. Here we go. So right here in particular, we have just sticking out and it's hanging stick straight and it doesn't move. It's just real stiff. Yeah, that's the bleach damage. Don't do this, ladies. She needs to go back to brunette and she could actually get her hair back to moving again. But this stiffness, this is all bleach damage. She should quit doing this. Quit doing this, ladies. Don't do it. Bleach it's not worth it. Be a darker blonde. Like I'm a blonde, but it's darker blonde, you know, so I don't have to bleach my whole head. Just go with highlights.
The 10th of February.
Scarecrow hair.
All right.
Yes.
So
like
paper
straw.
number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
I'm sorry, the opposition.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud.
A cloud,
we
yeah.
were told that this was an account of a retired detective, as explained by Mr. Brennan, We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video. Which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything.
It's pretty odd.
He went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name.
That's convenient.
He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud.
Call this case right now. Call it. This is the evidence we've been looking for 3 years. And they can't even get their story straight about where it is. Oh my God.
Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there.
Right. How could they get it from them?
And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information. It's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the
you know what
footage
it's
end
going
up
to
on the
show?
system? When did the footage end up on the system?
You know what the missing footage is going to show? Brian freaking Higgins talking to officers next to the car. How much you want to bet? How much you want to bet? Brian friggin' Higgins. That's what it will show. Him saying he was just passing through. I was just passing through. Yeah, I was in there like 800 times that, and I didn't go to bed that night. I went straight from the party and to the Canton police station where I don't work, and stayed there all night long, passing through where the car was multiple times. But yeah, he didn't talk. I didn't talk to anybody. Nobody told me anything. I didn't hear anything about this case. Nope. I guarantee you it'll show Brian Higgins on the tape talking to the cops, investigating the car.
Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point.
Yes, and I would also expect that it would show the taillight was intact, that it would show that the taillight was just cracked when Karen hit the car behind her when she was on her way out, and she backed into that car, and you could see the car behind her kind of move off the tires move. She cracked it. It wasn't shattered, but it was cracked. And I bet when it left, when it came in, when it pulled in, because that's what's missing when the car pulled in, something happened to that taillight in that police station. And what do you want to bet? It was shattered with a nightstick, and those pieces were taken and thrown all over the Alberts lawn. That's what I think happened. My God. Yeah, it would show somebody breaking a taillight. That's why this video is missing.
A fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there.
We know that. You already argued this at the last motion. That's not what we're talking about.
They filed a motion making representations that weren't accurate. I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th.
How could they not be entitled to it? This is so garbage. The defense wasn't entitled to come and download the DVR. Yes, they were. Yes, they were. The defense is entitled to, it's called Brady. You have to hand over everything you have. And just because they wanted to bring their expert to do the downloading or to supervise it, that they have every right to do that. This is full of garbage. Did I say he was better than Lolly? Maybe that's wrong.
The police officers, because we were here on.
Then they get there and there's nothing there, right? Nothing, just nothing there. Oh yeah, it's on the DVR. You can come get it, send your expert, spend $12,000, and then there's nothing there.
Dr. Russell, I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When
that's false.
State police would ask for.
That's false. They had a motion to preserve. That's so false. You had a motion to preserve 3 years ago. You had a motion to preserve all evidence in the case. That included video evidence. These people lie. Oh my God, they lie. There was a motion to preserve. Lies.
Download of a particular event like the Sallyport area. He would download it. What he told me is that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it.
Would you trust these people to download a video, the video that they've kept from you for 3 years? If it was your life on the line, would you trust these clowns to download the video that could totally prove you're innocent and give it to you properly without destroying it, corrupting it, doing something to it? Would you trust them? Or would you, like the defense, be like, hold on, we need to be there? There is no way I would let these people touch anything about this video. Yeah, whoops, we deleted it. Oops, yeah, they already inverted it and tried to pass it off like the original video, and there were huge sections of it missing. You remember, like, all the times when a cop on the screen would just disappear? It was like, this has been edited. It's clear. Oh, no, it wasn't edited. Oh, well, yeah, it is inverted. Yeah, actually, there are cuts in it. Where'd they come from? No, you can't trust these people. They're probably editing it as we speak.
No, we did that because the defense wanted us to. And also, it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed under the spirit of Brady violations and due process. It was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata.
Well, you find out.
Know exactly what they're looking for. This is
you find out.
Click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated
no, so the metadata will show you where it came from, where it went, what journey it went on before it got there. It will show you who clicked and dragged. It will show you all kinds of things. The idea that metadata, he doesn't know what metadata is. He's a prosecutor in 2025. Are you telling me he's never used metadata before? Bullshit. Bullshit. It's real easy. Get a tech guy, let the defense's tech guy get in there and download the metadata. Like you said, it's real easy. Let us image it. Oh, God, this is bad. He's pretending like he doesn't know what metadata is.
Then the only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to.
They've asked for all these accommodations. They want, something bizarre and otherworldly called metadata. We don't even know what that does, Judge. We don't know what that will show. We've never heard of metadata before. This is embarrassing.
Meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
Oh, I wouldn't let them do it.
I imagine we could do it one day, but today it'll get done by the end of the week.
She's going to let him do it, isn't she?
You want to make I'd be heard briefly?
Yes.
Very, very briefly.
He's going to let him do it.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that. Pretty immaterial what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data. And there's probably, maybe, log files. If there are, we're entitled to them. And he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it.
Yep.
That hard drive, every time it's accessed and the data on it is accessed, also will have metadata.
That's important.
Electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server,
who touched
every one
it?
of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told
talking about
from
Brady
day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you.
That was a lie.
In the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, We get more.
Get in the microphone.
This past October 24th,
Move
right
back.
after the trial, we get more video of
Thank
Brian
you.
Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the
October 24th. Did that video come with the metadata?
No,
No.
it's just video. It's a video file. And I'll also, that's a great point, Judge.
It should have.
When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it. And then there's going to be the file. So that's what we're asking for. This metadata associated with all those things. It's not a hard ask. It's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs or what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty.
What?
To provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much. All right, Mr. Unedi, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this
Is she not
motion.
going to make? She not going to make a decision on that? How long does it take? My feet are cold. I need socks. How long does it take? Exactly. How long? How long does it take to make up your mind of whether the prosecution should turn over the metadata which the defense is entitled to? Like, are we going to have to wait another week for her to make up her mind, or 2 weeks for her to make up her mind about this?
As Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Of course you will.
Would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
For those of you who don't know, Pro Hoc Vice just means that their attorney, the one on the Alessi, the one on the end here, he must be from out of state. So he needs to file paperwork, which he has done to enter the case Pro Hoc Vice, which just means from out of state. He's going to be, I don't know if that's the exact Latin, the English interpretation of the Latin, but that is what it means. So he can practice in a state where he does not hold a license. And any lawyer can do this in any state. You just have to usually pay a fine, not a fine, a fee, and also get admitted, and you have to have your license has to be in good standing, etc. But they always say yes if your license is in good standing for the most part. Oh, he's from New York? Okay, that makes sense.
Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes.
Is he gonna fight the Pro Hoc Vice?
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
What?
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent
Then why don't you
an
sit
accused from
down?
having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that's something that I think the court should consider and be thoughtful about for a couple of reasons.
Oh, here we go.
There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case.
Oh, here we go.
Not
That has not been
over a dozen
determined.
indictments against Mr.
By the way, that has not been determined by a court of law. That has only been alleged. Aidan Kearney is he is fighting that in court right now. His trial is coming up, I think. But so far, that has not been proven by the state. That is simply an allegation that this has been used to bully and intimidate witnesses. And bullying, by the way, there's no law against bullying anybody. So nonsense.
Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case.
So?
There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense.
So?
We've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly.
Hey, this is unbelievable. Who cares if Betterow is Aidan's attorney also and he wants to work on the Reed case? Who cares? I don't understand why anyone would care about that. And it makes perfect sense to me. Betterow knows the case really well. And why does it matter if lawyers are talking to each other who are clearly on the same side? What? I mean, Aidan has been leading the Free Karen Reed movement, and I believe Karen Reed would like to go free. That is not a secret. It's not a secret that their attorneys may talk to one another, and it's not illegal, and it's not against the law. So what the heck? This is really an argument that he's making? We don't want these attorneys because they're representing Aidan Kearney. What?
Allegedly have been harassed and intimidated. It is curious.
Wait, did he say allegedly?
That allegedly have been harassed.
No, good. I'm glad he said allegedly.
With witnesses in this case that allegedly have been harassed and intimidated.
I'm glad he said allegedly this time because he didn't say allegedly last time. And it has not been proven that they have been harassed in any way. It has not been proven that it wasn't just the First Amendment right of Aidan Kearney and the people that he was protesting with to speak their mind in public. It has not been proven that it was harassment. So I'm glad he said allegedly.
It is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about in a sanctions motion.
Yeah, let me make it easy for you. Let me make it easy for you, sir. They all hate you. They hate your case. They hate the state. They hate the cops. All of these attorneys think that you guys set her up. Does that make it easier for you? That's the relationship they have. Does that make it easier? They can't stand you and they think your case is shit. What is he even getting at here? There's an illegal basis for this non-objection objection. So remember, he gets up and says, she's like, I didn't want to hear from you unless you were objecting. Is this an objection? No, I'm not objecting. I'm just want to say some things for the television screen. Because that's all this is. This is for the TV. This is for the fans. I'm going to try and make it look like there's something underhanded going on between these attorneys because they know Aidan Carney and we know he's a bad guy. And we've told the media he's a very bad guy. I mean, there's no reason for him to be doing this. If it was an ethical problem, the judge would have already, she knows, she would have already said no. She was going to say, okay. She was like, this will be an easy one. I just sign off on it because it's pro hoc vice. Why is it curious? Yeah. Why does he keep, but it's curious. Well, it's not illegal in any way, but it's curious. Well, we're not interested in what your curiosities are, sir. Just try the case. Good Lord.
Direct violation of protective orders in this case.
Wait, what?
Violation, delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a direct violation of protective orders in this case.
Well, all right, save it for your sanctions motion then. Doesn't that give your sanctions motion more teeth? If you can now you've got the other guy that you think did the violation right there in the case. Doesn't that put more weight behind your sanctions motion? I'm sure that Auntie Bev will give it to you. She loves you guys so much and she hates the defense.
Provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery. And much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings.
Why are we protecting all of this stuff, by the way? Why are there protective motions over the evidence in this case? I mean, as a member of the media, I am against protective orders generally, unless they involve victims, like minor victims. That's pretty much the only exception that I make. Anything else? Why are we hiding all of the evidence? Why are we hiding the evidence in this case? Why are we putting protective motions over evidence in the case? What are they worried about? What are they worried about the media, thus the people, seeing? You should ask you. I think that's curious.
And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned.
That's what he's worried about. All of the shit we did that we don't want anyone to know is going to come out. That's what he's upset about. Yep. That's what he's mad about. There it is right there. We have things we're hiding from you, the people out there, and we're sure that Betterow's going to make sure it gets leaked.
Concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses.
Oh, stop it with the harassment and bullying of witnesses. And also, the state's evidence should never be suppressed and kept from the people. Whatever evidence the state has ought to be posted on a public website. Like, what is this protected information? I really need to know. What are they protecting? The solo cups? What are they protecting? Or is there more information like that they're protecting? Good God.
And this information, if a court order won't protect it, then nothing will.
A court order shouldn't even be made to protect the state's evidence. It shouldn't even have happened in the first place. There should be no protective orders over the state's evidence. Why? Why are we even doing that? Does anybody know what he's talking about? What was leaked that was supposedly protected? Does anybody know? Let me know.
And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each.
So?
And so,
he's a reporter.
Not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether this protocol.
So I'm not objecting, but I want you to object, Judge. I'm not objecting, but you should, and you should use your judgy powers to interrogate these attorneys about their attorney-client privilege. That's what this is about. Ex parte, we won't be there. What?
Protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know
what
how to describe
leaked
the relationship. I'm asking the court
I want to know what
consider
leaked.
assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And
stop it.
Issue. The defendant.
Nobody has the right to walk into a public courtroom without getting heckled on the sidewalk. This is America, sir. And if you've acted like an ass in public, people might heckle you on the sidewalk. And I'm sorry, but I have rarely, if ever, seen anybody behave as badly on the stand as Jen McCabe and be as unbelievable a witness as Jennifer McCabe. She is one of the most unlikable, unbelievable witnesses I've ever seen in my whole life, ever. And Brian Higgins, too. He was pretty bad. It made me seriously question Karen Reed's, it made me question her, what's the word I'm looking for? Her judgment that she was interested in a guy like Brian Higgins. Because my God, that guy, I'm sure he was a D student. I mean, he was just very bad on the stand.
Is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Oh, right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay.
What? Of
All
course.
right, the next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay. There's no objection to this.
They should never have let her do that interview. Stupid.
Yes.
Not when they knew she was going to be retried.
allowed.
Totally stupid. And you cannot trust the media. And it might be nothing, but they'll
So
twist it
next
and
is
use it
paper
against her.
490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis.
All right, before we get to this motion argument, let's get to some of the super chats. Uncle Frederick, thanks for the whatever that is. Hey, I really think you should get the car thingy your husband wants you to use. We've all seen you drive an 18-wheeler. Yeah, I don't think I'm going to do it. The Silver Leaf, thanks for the 2. Wait, did you say evidence in a solo cup? Yes, I did. They put blood evidence in solo cups and fast food bags. Frankie, 3131, thanks for the 10. Your coverage of cases is awesome. Well, thank you, Frankie. I appreciate that. Slug Entertainment, thanks for the 2. Very true. No bullying laws. I can bully grandma when you do all day long. Daily Dysfunction, thanks for the Canadian 2. I see Runkle's face on that guy's screen. Whose screen? Did you? I didn't see it. The DCV Titan, thanks for the Canadian 2. Prosecution has to pad those hours somehow. Yeah. And this is a good time to remind you, if you like the program, please make sure you hit the like and subscribe. I'm looking to get to 75,000 subscribers sometime soon. And if you appreciate the entertainment and you want something else besides the Hales case, which is what I've been covering almost exclusively, then make sure you support the show. Make sure that you send a super chat if you can. If you do not send me your ramen money, by the way. If you can only afford ramen right now, do not send that to me. Obviously, take care of your needs first. But if you have some Starbucks money laying around you were going to waste at that garbage place, you can send that. I will take Starbucks money. And you can also, if you don't like sending super chats through YouTube, you can send them to Cash App or Venmo, which is rolling across the bottom of your screen. Or you can support me at meganfox.locals.com, where we have a live chat going right now. And let me actually check over there. How you guys doing over there in the locals chat? Let me refresh my screen. Sometimes it doesn't refresh for me. I've been posting the hilarious Valentines over there that were trending on Twitter over the weekend. So funny. Have you seen some of these? Let me show you the locals chat real quick. So this is so funny. This is the one that, hold on. This is the one I put up today. There are so many good ones. So everybody say hello to locals. Hello, locals. And we will, I will check in on you in a little while. All right, let's see. Where is the, here we go.
I assume counsel has seen this affidavit of Mr. Diller.
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right. So no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay.
All right, I'm going to use our handy dandy little super chat goal. I'm going to pick a goal of 10 super chats for the next 30 minutes. And if we hit it, I will not turn on the commercials, because right now we have monetization turned off. But if we can't hit the goal, I will just turn them on. That's what I will do. So if we can get 10 of all the colors, any colors, doesn't matter, in the next 30 minutes, we stay with no commercials, which I prefer. I like keeping it off so that you guys don't get interrupted, you know?
I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. And, I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But, we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material, and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
Let's wait. When I said both, I thought the points taken over.
Understood.
What?
Understood.
All right.
Wait, super stickers don't count? I didn't know that. Do they not count? That's terrible. I said all. Okay, I guess super stickers don't count. I didn't realize that was the case. Where are we at? Let's see. I think we were at 6 out of 10. Yeah, we're almost there. So I think you guys will hit it.
So, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial.
What is it that the defense doesn't want to turn over? I may have missed what it is that they don't want to give to them. Something to do with Proctor. And if he was, I think that the prosecution is right in this case. It is both ways. You have to turn over everything to the state, and the state has to turn over everything to you. Impeachment evidence, I think that includes impeachment evidence. So, I mean, the defense has to turn over what they have to the state. I don't think that that's unusual. That's the law. But if they have a concern, and this is what it sounded like to me, they had a concern that Proctor was watching the trial, so he knew what was coming. It's the text messages from Proctor to Lolly after the trial. That's what. Well, why couldn't they just get them from Lolly anyway? Are you telling me Lolly hasn't given those to the state? That would be strange. I mean, doesn't Lolly work in the same office? I would imagine that he could just ask him for those. But I don't think that the defense can withhold that stuff. I mean, let me see what the chat says for a second. Yeah, but then again, the Commonwealth complaining that the defense has not given over stuff they have to give over is really rich, isn't it? Considering that we've been looking for a video for 3 years. This video they keep on saying they don't have, then they do have parts of it. Oh, and look, here's some more parts of it. And, well, we can't give you the metadata. And yeah, that's a lot. Hold on, let me read the chat. See if you guys can answer my question. The defense doesn't want to give all the questions before asking witness questions. Well, I don't think they have to give over their questions. What they're asking for is they don't have to give up like what they're going to ask, but they have to give up any evidence. Like, for instance, I think one of the things Brennan is talking about with the last trial, with some of the evidence that came out that the prosecution didn't have, were the photographs of the McCabe's and the Alberts, you know, all up in each other's business all the time and at each other's weddings and went to high school and like all these went to some baby shower together, like these, you know, when they said they weren't that close and yet they're at all these events together. I think those came up because they got them in the middle of trial. But I'm not sure if you can withhold anything. But I could be wrong. But I don't see the judge being like, yeah, no, they don't have to turn it over. I'm sure that she will make them. Let's see. Lady Tammy says last time they were ordered to turn over everything they were going to impeach with, and that gave Lolly time to coach the witness's testimony, and it all changed from previous testimony. But isn't that normal anyway? Don't they have to give impeachment evidence? Let's see if we can Google this. Hold on. Hold, please. All right. We have a legal encyclopedia here. All right, it sounds like this has been a hotly contested issue. So defendants have argued that forcing them to turn over evidence to the prosecution in advance of trial violates their Fifth Amendment right to silence and the privilege against self-incrimination, but courts have upheld so-called reciprocal discovery laws. And then if we go to the legal encyclopedia, let's see what it says about this. Why didn't it go there? That's weird. There we go. The prosecution usually has to disclose more information than does the defense, but that doesn't mean that defendants can sit on their hands. Most of the law regarding discovery in criminal cases focuses on what the prosecution must disclose to the defense. After all, the prosecution is the side with the most information and resources. But at least in some sense, discovery is a two-way street. Defendants have to turn over certain information to the prosecution. This obligation is referred to as reciprocal discovery. Defendants have argued that forcing them to turn over evidence to the prosecution in advance of trial violates their Fifth Amendment right to silence and the privilege against self-incrimination, but courts have upheld the so-called reciprocal discovery laws. It's worth noting that in many cases, specifically those that settle well before trial, the defense doesn't end up turning anything over to the prosecution. So the evidence that the defense must turn over would include, it says each jurisdiction has its own reciprocal discovery rules. Here's some partial examples of the kinds of information defendants routinely must disclose. All right, we're not in federal court, so let's go to Okay, so in federal court, if the prosecutor demands it, the defense must give written notice of intent to offer an alibi defense and reveal the names and addresses and telephone numbers of the alibi witnesses. In California, defendants must disclose to prosecutors the names and addresses of all people other than themselves whom they plan to call as witnesses, any relevant statements by any of these witnesses, any experts' reports, and any real evidence, tangible objects that the defense intends to offer into evidence. Okay, so that would include text messages between Proctor and Lolly. But that's in California. So I'm assuming that Massachusetts it's the same. Let's see. Let's see if Massachusetts is the same. Massachusetts reciprocal discovery. Oh yeah, here it is. What was he saying? 14A1A. Automatic reciprocal discovery to the prosecution commences only after the Commonwealth has delivered all defense discovery required. Well, now, how about you turn over that video? Have they turned over everything they were required to turn over? I don't think so. So that's what I would argue. I didn't hear the defense make that argument, though. Why? It says so right here. Under subdivision A1B, it only commences after the Commonwealth has delivered all defense discovery required pursuant to the automatic discovery provisions, and they have violated it. They have violated it. I did already talk about my hair, but it's an easy answer. I went and got my hair colored and cut, and so I had a professional blowout done. That's why it looks so good. So it always looks good when the hairdresser does it. So that's curious. What's Rule 14A1A? Let's see what A1A is. A1A. Okay. So, that doesn't seem to match up. All right, I'll keep reading this while we watch and see if I find anything.
Will be abided by.
Okay.
Did
Was there any follow-up to that?
Are we
The motion for
sidebarring,
sanctions will
or
be a little bit
what
later.
happened to the
One
sound?
thing I would point out, Your Honor, Gabe, I should say.
What the heck?
To the
Sanctions will be.
Can you hear it? I can't hear it all of a sudden.
Your Honor, is that with regard to the
Hold on.
of
My sound got turned off. How did that happen?
It will be trial by ambush. It will be.
What the heck?
There is no
I got no
caveat or
sound.
exception for the defense, and since
Did we hit the
there's
goal?
no time
That's
to
cool.
withhold
Wait,
any
why do I have no
material,
sound? And you can hear it, but I can't. Damn. All right, I'm going to have to maybe shut down. I have to restart YouTube. That happens sometimes. I don't know why. Also, it could be my headphones. No sound for me. All right, so we don't have to put on the ads, which is great. We'll get to those in just a second so I can pull up. Let me try and pull this up now. There we go. Now my sound is back. Sometimes I have to do that. I have to restart YouTube. It's weird. Very weird. Hang on. All right, let's get to your super chats real quick. And Sticky Widget says, thanks for the toot. Commercials equal the devil. I agree. I don't like commercials during live streams. I like to keep that off. I usually turn on the monetization after the live stream. Monica Kellett, thanks for the $10 super sticker. Appreciate you. Dancing with the Devil, thanks for the 2. And Lady Tammy, thanks for the 2. Take my darn money. I appreciate it. Rebel Bird, thanks for the 10. No commercials. Let's go. Daily Dysfunction, thanks for the Canadian 2. I always want to say California. They're still not a separate country, though. Are you and Tug streaming tonight? Yes, on his channel. We will be on his channel tonight. King Bob, thanks for the $2 super sticker. Appreciate you. Pimp Stick, thanks for the 5. Cough it up, bitches. The Foxy Lady works her ass off. It is a difficulty sometimes, but I do enjoy it. I love it. Lady Tammy, thanks for the 2 for one of those super stickers. Why don't the super stickers count? I feel like I would count those though. Like I would, if we didn't hit the goal, I would have counted the stickers. Janice MB, thanks for the 2. Loving for my for Fox sake hoodie. Been promoting you. Oh well, thank you. I love the I have the t-shirt. And I enjoy it too. I haven't worn it in a while. Dan Davis, thanks for the $2 super sticker. Appreciate you. Auntie Audi, thanks for the Canadian 14. Here's my Starbucks money. Yeah, $14 at Starbucks these days would buy you like what? A venti frappe or something. I mean, it's crazy how much they cost now. Equality, thanks for the Canadian 2. My Kit Kat money. I'm trying to lose weight. Perfect. Dancing with the Devil, thanks for the 2 for no ads. It's good. You guys you like having no ads. Me too. I like having no ads. All right. I don't know if it will let me do another goal. I'll try. We'll try to do all the colors. Yeah, all the colors. We'll try to do another one. No ads. But this time, since you guys met that one super quick, we'll make the timer a little longer. Make it 45 minutes. There we go. All right. Did it work? Okay, it's worked. It worked. Yay. All right, let's share this. No, that's the wrong button, Megan. Don't hit that. There we go. No, that's the wrong one too. There we go. All right. Let's put this back up there.
And it's going to create an unfairness.
Oh, I have to.
It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, will be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense discovery than they're entitled to as early as we can.
Then why has it been 3 years since you turned over the video and it still hasn't been turned over? Why?
All right.
Bullshit.
Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those.
Right after Brennan gets done with his self-important little, Your Honor, we are doing the best we can to turn over everything in a timely manner. And I am on the side where I do not like getting late discovery. And we are doing the best we can. As soon as he gets done, this is another motion to compel more discovery that the Commonwealth has withheld. Are you kidding?
In turn.
10 items.
The first request deals with.
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or
yes, of course, Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions, one before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sally Port garage. Another production in the middle of trial, which included an inverted video showing only the left portion of
Look
Ms.
at this
Reed's
guy
taillight,
behind her.
not the condition of the right
Look
rear
at-
taillight in the Sally Port garage.
Look at the guy behind her. Who is this with the in the turtleneck? Does anybody know who this is? Look at his facial expressions. I'm going to back this up. Watch him. It's funny.
How the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct
Karen's
production
dad.
of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sally Port garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sally Port garage when it was first brought in.
Yep.
Then we have a third production, which was not turned over until after trial in this matter.
Oh.
In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions.
By the way, didn't Brian Higgins deny that he could remember who he was on the phone with at 1:30 in the morning? I think he did. I think he said he couldn't remember. And of course, his phone records are all gone because, you know, he destroyed the SIM card and tossed the phone on a military base. Didn't he say he couldn't remember? How could you not remember who you were speaking to at 1:30 in the morning, the night John O'Keefe was found dead? How do you not remember who you were talking to? It was a butt dial. He denied he was on the phone, and he's on video being on the phone. Yeah, I'm sorry. And this is another thing that the juror interview that Aiden did made me absolutely crazy, because they didn't understand. Somehow they did not understand the significance of these people lying about being on the phone. They didn't get it. Like, you really have to lay it out for these people. You have to spell it out for them. And you know what the craziest part of that interview was? At one point, the juror was like, well, we thought that, you know, she might have hit him, or we thought that maybe something else had happened. I can't remember what he said. And I'm like, that's reasonable doubt. If you thought she might not have hit him, if you thought he could have died in a different way, that's reasonable doubt. You have to say not guilty. These people were not instructed on what reasonable doubt is. And that's, frankly, it's on the defense attorneys for not explaining it and pounding it into their head. It's maddening. We're going to have to go over that at some point.
Or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence.
Oh, but they
in a
did.
report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore.
Ooh.
There's certain names that this court will recognize. First responding officer, Sergeant Link.
Oh.
Detective, Kevin Albert.
My
Trooper, Mike Dunn.
God.
Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully.
Really?
Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey.
Oh my God.
All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer.
Mm-hmm.
It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect.
Holy shit. It's so true. We covered that on this channel. We covered the Sandra Birchmore thing, and oh my God, the documentation in that is, oh, it's so bad. The arrest affidavit that we read here on this channel, if you don't know about the Sandra Birchmore case, it is so heinous. Sandra Birchmore was groomed as a 12-year-old. She was in the Canton. Was it Canton? Was she in the Canton one or was it Boston? She was in, I think, Canton. It was like a junior program for junior officers. And an officer groomed her sexually from the time she was 12 and had a years-long predatory relationship with her until she was an adult, got her pregnant, and then because she wanted him to own up to it, he killed her. And it was Stoughton. Okay, that's right. It was Stoughton. But a lot of the same officers were involved. And he killed her, and then all of these officers covered up for him. They called it a suicide. And like they had evidence, the evidence is that when he went into her apartment, and they have video, there's video surveillance, her cell phone and health information stopped moving, but when he, before he left, and never moved again. And he's finally under arrest for that. And his brother was involved. And yeah, he staged a suicide. He was even in her closet. She reported to someone that he was skulking around in her closet, which is, of course, where she was found. She lived in Canton. Okay, so it was the Canton police that did the investigation, which was garbage. Wow. Her voice sounds weird because she's nervous. Her voice is shaking. That's why she sounds like that. It was a really bad case, and it turns out that a bunch of the same investigators were involved in this one. Oh boy.
Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again deals with the clearing of a fellow officer.
Yep.
And I would cite
damn straight it does.
For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case.
Yep, I knew this.
Reached certain opinions and conclusions. Also analyzed electronic data in the Birchmore investigation.
Yep.
As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct. Nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder.
That went back to when she was a minor.
Available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that.
What's Bev going to do, you want to know? She'll deny them. Bev hates the defense. She's full on in with the prosecution. And yeah.
He had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is.
Yep.
This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place.
I'm with you, chat. I wish her voice wasn't shaky. I don't know if this is just the way it sounds. Women do need to be careful about this because, women and girls have a tendency for their voices, for when they start talking, men stop listening and other women get annoyed because of the tone and sound of the voice. It's like scientifically proven that higher register, the higher your voice is, the less other people listen to you. And so it's one of the reasons why Elizabeth Holmes did that, that very deep voice that, people would take her more seriously. And they did. It is something she should work on with a voice coach. It would help because she's very good at her motions and her arguing, but the voice, the shakiness and the cracking and stuff, she should just go to a voice coach and work on it. I mean, newscasters do it all the time.
Deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will.
I heard
the
that.
Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts.
That's funny.
Now that he's on the receiving end of that request, he's objecting to it.
He doesn't like it.
All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
Oh, I can't wait for his argument about this. The Birchmore case has nothing to do with us, even though half of the witnesses were involved in her investigation too.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something
sure about that
is not in writing, that there is no witness for. The defense has asked a chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
It has everything to do with this case.
Terms and words for our audience that's here.
It has everything to do with the case. It's about cops covering up for other cops. It's about a cop who committed murder, and then the same witnesses in this case covered up for him. So how do we know they're not doing it in this case? Same people. Really? Bullshit. I want to know why Brian Higgins, who works at the ATF, was given full access to the Canton Police Department and was there all night. That's what I want to know. Well, what was he doing there? He doesn't even work there. They just let ATF agents just wander around the Canton Police Station during an active murder investigation of which he was a witness. Yeah, they are doing it in this case. This has everything to do with the Sandra Birchmore case. It is the culture. It is of this police department. It is the culture of these cops to cover up for one another. I don't even think I'm going to be able to listen to him make this argument against it. This is going to make me angry.
There on our right to try to create an illusion of impropriety.
An illusion of impropriety? You put blood evidence in solo cups. You used a leaf blower to uncover evidence. Trooper Proctor called the defendant How many times did Trooper Proctor call her the C word? How biased was he against the defendant? There was no such thing as an unbiased investigation in this case. He hated her. Proctor hated Karen Reed. They all talked about her. They all made fun of her. They were looking for nudes in her phone. They obviously hated her. Fuck.
They have
It's gonna
provided
piss me
about
off.
the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here.
He did. He cleared him.
I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong.
He didn't find the 10,000 messages. He only found a few messages that showed that he was in a consensual relationship with Sandra Birchmore as an adult. He conveniently didn't find the 10,000 messages that went back to when she was a minor. He conveniently didn't find any of the BDSM violent fantasy stuff in there. Ugh.
In a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case?
Oh, I don't know. It seems pretty relevant to me.
Work on many cases. That case certainly has a public appeal to it.
No, it's about cops covering up for other cops. That's why. It's about cops getting away with murder. That's what makes it similar to this. Because a bunch of us believe that some of these cops covered up a murder of John O'Keefe. And the Birchmore case proves that they can do it. Because how many years? Hold on. When was Sandra Birchmore found dead? She was found dead in 2021. Her killer was not charged until 2024. And it was because they had closed the case and called it a suicide because the cop friends made sure it was a suicide. Bullshit.
Because of the harshness of it, the sadness of it. But what does it have to do with this case?
Oh, everything. Nothing. Everything. Has everything to do with it.
Helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And
all right, we'll get right back to that in just a moment. Let's get to your super chat, shall we? We have 16 minutes to meet the next goal, so I don't turn on the commercials. The next goal, we're at 4 out of 10. So we need 6 more before the next commercial, or before not commercial, in 16 minutes. Let's see, where did we leave off? I believe it was right here. Sticky Widget gifted 5 Megan Fox memberships. Welcome to the Fox Den, all of you who got those. That was very generous of you. Thank you very much. Dancing with the Devil, thanks for the 5. Woohoo, let's do this. No ads. Life According to Martin, thanks for the 2. No chain of custody. The case should be booted. Yeah. Yeah, it should have. It should be booted for the double jeopardy. By the way, that appeal, they're appealing that. They're appealing the appeal ruling. So I guess they're going to go to the Supreme Court of Massachusetts, or is that where they did go to that appeal? I'm actually not sure, but they're appealing that. Hopefully that gets looked at again, because this double jeopardy thing sucks. Death's Angel, thanks for the 2. Hugs and love to everyone. Good to see you. Hit the like. Don't forget to hit the like and subscribe. I'm always bad at reminding people to do that, but make sure you do. Help the algorithm a bit. Pumpkin Farm, thanks for the 2. Oh, Megan, just wait to see what happened next. I'm on the edge of my seat. Death's Angel, thanks for the 2. Rage, this man is horrific. It's frustrating, right? He's not as frustrating as Lolly, though. I mean, he made my anxiety go over the roof. Donna says, my anxiety is over the roof. I don't like this guy at all. Is he BBB's brother? Oh, no, BBB is way worse. Trust me, way worse. Okay, so we are at 6 out of 10. 4 more, so I don't have to turn on commercials. Now, you know you don't want to watch commercials while we're doing this.
I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point. So.
Yes.
All
She
right.
takes everything under advisement. She never makes up her mind.
All right. So next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So,
They want to
Ms. Brennan?
exclude ARCA? Really? Of course they do, because ARCA, by the way, it wasn't ARCA. It were the Fed's experts, right? The federal investigation that is going on. So ARCA, which is unfortunate that wasn't explained to the jury properly. They thought that the defense paid them, and I don't think that's what happened. The ARCA experts were with the Feds, and their testimony basically debunked the idea that John O'Keefe could have sustained the injuries he sustained by being hit by a car. And just like, what's wrong with the jury? Like, what was wrong with them that they didn't see that this was all a total cluster? Crash Daddy and his cannon. That's right. Crash Daddy and the cannon. The cannon witness. I forgot about him. Oh my God.
Sure.
The defense wasn't allowed to tell the jury who they were. Right, because if the jury knew that the Feds were investigating the investigation, they'd be like, oh, this is a big shit show. But also, I blame the defense for not educating the jury as to how a police investigation is supposed to work. A police investigation is supposed to follow certain guidelines, and this one didn't. And they did not hammer that into their heads. They did not come away with the idea that the investigation was that screwed up. We did out here because we were like, able to discuss it amongst ourselves. And this is one of the problems with the jury not being able to discuss these things with each other, even when, and also not able to ask questions. Massachusetts is one of the states where the jury doesn't get to ask questions. And I've come to the conclusion that the jury being able to ask questions is a really good thing because it clears up some confusion. After your people testify, like in the Kowalski case, the jury was always allowed to ask their own questions of the witnesses. And I think that's a good way to A, keep them engaged so that they're not falling asleep, and B, clearing up any confusion they might have about police investigations. Like, is this normal? Is it normal to put blood evidence in solo cups? Is that something that you do usually? Is that how you were trained? No? Oh, did we hit it? Did we hit the goal? Yay! I don't have to turn on the ads.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813.
She doesn't remember?
June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
What? What is it?
Trial and reading the transcripts, I only have a flavor for the last trial.
Why haven't you watched
So
it?
there's email correspondence between
It's available.
the defense.
You know, this guy keeps on saying this. Well, I wasn't at the last trial. There's nothing stopping you from going to Law and Crime and watching the whole trial back. Why haven't you done that? If I am having to try this case, I'm going to watch every second, right? Why does he keep making excuses for why he hasn't watched the trial? That sounds like a you problem.
Not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
The date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment.
What do you mean I've turned over a lot? What does he mean? I've turned over a lot less than this. Did he mean to say more? That didn't make sense to me. I've turned over a lot less than this. Oh, I see what he's saying. He's saying this is something that should have been turned over to us because it's, very detailed or whatever. I don't know. Again, this is that reciprocal discovery thing. And each one, if the rule is right in Massachusetts that says the defense is not required to turn over all of their stuff until the Commonwealth turns over their discovery, well, then they're still in the clear. We're still waiting on that Sallyport video. We're still waiting on that. Yeah, they put evidence in fast food bags, you guys. Like the investigation was a total shit show.
Visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit.
Let me get this straight. I thought that ARCA did not, that they did not pay, the defense did not pay them. They did? They paid them $23,000? If that wasn't disclosed, that's a problem. It is. If it wasn't disclosed, that's a problem. Did they know that they were going to? I thought that they were federal witnesses, federal experts. Did you guys know that they paid them? I mean, I could see that being a problem. So Mochi says defense confirmed after court they didn't pay. It's after for hotel and flights. All of this was turned over by the defense. That's not what he's saying. He's saying that he got it through FOIA through the federal government, that they did not, the defense did not turn this over. I mean, who would be responsible for paying the ARCA expenses? Polly is saying, no, they didn't pay them. Well, then why does he have an invoice that says they're owed $23,000? Okay.
How it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before we
Court, all rise, please.
All right, recess. Pamela Fanderson. Isn't that Pamela Fanderson? Was that, did Jeff covered this trial, didn't he? Jeff always liked to name the fans, the ceiling fans. Or was it Celine Dion? Celine, he had another one that was like a playoff, Ceiling Dion. Oh my gosh. How long is this? Recess is my favorite, says chat. Let's see if we can move forward here. Ceiling Dion is still fanning. Jeez. Okay, here we go. Do you hear that? Or is the sound not on? Because I can't hear anything. Is my thing screwing up again? Oh, here we go.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Oh
so for
boy,
that reason,
here we
I'm going
go.
to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
Oh, you've got to be
So
kidding
I'll see
me.
you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
So they're not even going to get to defend themselves? And now she's suggesting they need lawyers.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by
Oh, great, thank you. We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Thanks. Thank you.
Peachy Peaches, yes.
We'll do it live. Fuck it. Do it live. I'll write it and we'll do it live.
This is something else. Like, why doesn't she just let them respond? I don't understand why she's suggesting that the defense attorneys need their own attorneys.
Okay. All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise to the court, please.
I don't understand why she's doing this. Why not let him hash it out? Why not let them hash it out? And I know you guys are saying he walked it back and said he didn't get it from the feds at the end there, but I didn't hear that. I heard, hold on. Let me hear what he said again.
Experts.
Hold on.
January 4th, we sent the chronology. I think Your Honor should be aware of. If I could add that right now.
I may need to take notes.
Less than a minute. The chronology is December 4th. We sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th,
so
that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
It doesn't sound like any of the information was provided to him by the federal government. And then she goes and asks if she can have the information from the federal government, but the emails he read came from the defense. So why is she still asking for the stuff from the feds? They didn't send him anything. All they sent was one email that they also sent to the defense to say the contract had ended. Yeah, he made it sound like it was all from the federal government. Huh. This is a disgrace, Duncan, Idaho. Good to see you, by the way. Of all the things for Auntie Bev to be gravely concerned about up until now, this is all such a disgrace, rotten from top to bottom. Yeah, of all the things that she could be disgraced about, right? She wasn't gravely concerned about the evidence in the solo cups. She wasn't gravely concerned about Proctor's text messages calling the defendant the C word. She isn't concerned. She wasn't gravely concerned about all the butt dials that the witnesses expected us to believe that they made. 7 butt dials in a row, by the way. And how someone's ass is answering a butt dial, I will never know. She is not gravely concerned that the Commonwealth did not turn over a video of the Sally Port and still to this day has not turned over that video. But she is gravely concerned about this hullabaloo with some emails with ARCA. And let me get this straight. Is it true that either side could have used these experts, but the Commonwealth didn't want to because what they came up with didn't help them? So the defense reached out to them. The defense wanted to use them and did, and then paid their expenses. So what? Is that a big deal? I don't know. It could be, I guess. I'm not sure. All right, let's get to the super chats. We got that one. And I have my favorites. Thanks for the 2. Breadsticks with extra garlic and butter. I like extra garlic and butter. Monica Kellett, thanks for the 2. Here's another one. I appreciate you. And Auntie Audie, thanks for the Canadian 2. This guy is such a liar. Well, yeah, he just misled everyone and the judge into thinking that the feds sent those emails and it was the defense. I have my favorites. Thanks for the 99-cent super sticker. Appreciate you. King Bob, thanks for the $1. Appreciate you too. I have my favorites. Thanks for the 2. Here's some garlic bread too. Monica Kellett, thanks for the 2. Appreciate you. Sticky Widget says, Megan Fox only at vampire keggers. Do they put blood in solo cups? Right. Vampire keggers. That makes sense. Shooting Star, thanks for the 2. One of the jury was an ex-cop and he was the foreman. Oh, God. Tammy Main, thanks for the 2. Such corruption and rights violations. Dismissal. It should have been dismissed a long time ago. Tammy Main, thanks for the 2. I believe they paid per diem for testimony. That's a big per diem. Of $23,000. Pumpkin Farm, thanks for the 2, because they have to pay them now because they're no longer feds. They're no longer working for the Fed. Is that it? Duncan, Idaho, thanks to the 5. Oh, yeah, we just read that one. Wow. Wow. I mean, all right. So hold on a second. Let me go over to Twitter. I mean, Twitter must be blowing up right now about this. Let's see. Let's see who's talking about this, shall we? All right, looks like here's Danny on is she live now? Interesting. Okay. Just Nick Starro said, just started watching the Karen Reed hearing today and my jaw hit the floor. There is more video and it's not on iCloud. Yeah, apparently not. Who else? So this is the way they're spinning it. The defense hid secret payments to defense experts to make false claims regarding John O'Keefe injuries. Yeah, that's not how I read that. Although it would be strange if they said they didn't pay them and then they did. Let's see, who else? More clarification on ARCA emails. So why would Jackson turn over emails that would have serious repercussions? It doesn't make sense. Right, that doesn't make sense either. This is infuriating because it's incomprehensible that she wouldn't let them just explain themselves. What? I mean, don't you normally, if you have an expert that's going to testify, don't you normally talk to them about what their testimony is going to be? Why would that be such an issue? Huh. Well, it looks like the lawyer you know, I think, is live now. So I'm going to send you guys all over there. And we can all go listen to what Peter has to say about this, because this is all very confusing. But he does a great job. So I'm going to send you over there. You go have a wonderful day. And I will see you guys tonight at 8 p.m. on That Umbrella Guy. I'll be over there at 8 p.m. Go tell Peter I said hello. And I'll talk to you guys later. See ya.